SJC-11821, Commonwealth v. Tyshawn McGhee, and another.
Good morning, Ms. Town.
Good morning. May it please the Court, my name is Sharon DeMond, and I represent Mr. Tyshawn McGhee. First and foremost, no one here is advocating for sex trafficking or human trafficking. Everyone agrees that this is a societal problem that needs to be eradicated. However, the statute that seeks to do that needs to comport to the constitutional requirements. If I may, I would address the vagueness of the statute, Section 50, as applied in this case before I turn the podium over. Excuse me. Simply put, Your Honors, Section 50 does not align with the common understanding of human trafficking. That is, without the element of force or coercion, it simply does not give reasonable notice to a person of ordinary intelligence that if they merely aid or assist a willing, known prostitute, then they will now be elevated to the level of a sex trafficker. And in doing so, will then face...
So it's okay to commit the crime of... It's okay to commit the crime that's already on the books, but you should get notice that you might be prosecuted under a more serious crime? Is that what you're saying?
What I'm saying, Your Honor, is we are not operating in a vacuum here. The statute's not in a vacuum. We already have a statute that addresses this kind of behavior and criminalizes pimping, if you will.
But the Commonwealth distinguishes that. The Commonwealth says that that pimping is essentially a retrospective look on the circumstances that a John gets paid. He doesn't, without necessarily knowing who the clientele are in advance. Whereas here, they have to know in advance and participate in the event. So that factually, the layout is different.
I disagree, Your Honor, and I suggest to the Court that the Appeals Court has addressed this question. Now, obviously, the Appeals Court is not a precedent here. However, I say in the case of Commonwealth versus Datania, and I apologize for mispronunciation of the case, the Appeals Court specifically addressed the statute and distinguished it between pimping, which is defining what they did in this case, and people that come on after the fact, being a joint venturer or aider and abetter, which is actually what the Commonwealth's position is. So I would suggest to the Court that has been addressed, and it came out, in fact, on our side, is that the statute directly addresses the behavior, the pimping behavior, if you will, which is acquiring Johns for the prostitute versus someone who just comes on after the fact and shares the proceed, being a friend, a joint venturer, or someone who just aids and abets.
You're suggesting that 272.7 requires you to be involved in the actual act of prostitution? I mean, arranging for it? Is that what you're saying?
What I'm saying, Your Honor, is implicit in that statute, Your Honor. Yes, it doesn't specifically say, but part of the statute, part of deriving support from prostitution, I would say, implicitly, what does it require? It requires support, it requires transportation, it requires acquiring Johns. So I submit to the Court, implicit in that statute, yes, it would require all those corroborations that you have in this case. Now, if I may get back to the statute itself and the title of statute, as the Commonwealth suggested, the title of the statute is Trafficking Persons for Sexual Servitude. The word servitude, by its definition, means slavery, means utter and complete control. Those are not the facts here. The facts here is we have 3 willing prostitutes, 2 of which were prostitutes before, testified they were. They had advertisements already on Backpage, 1 of which was already being pimped by Ellie and Ray. We have the 3rd person who testified, corroborated by Detective Figueroa, that the defendant said, we will not make you do anything you don't want to do.
Yeah, but doesn't our case law indicate that in order to ascertain the intent of the legislature, we look to the words of the statute, we don't look to the title?
Yes, Your Honor. 2 things. One is that, again, I suggest we don't operate in a vacuum. If so, if we were to look at the words of the statute, looking at the words of the statute, we can't overlook the word subjects. It's the first word that starts the statute. So I would suggest to the court that the word subject is very much a term of art in this case, and in Yates versus U.S., as the Supreme Court has held, the words have different shades of meanings, and that meanings may vary to meet purpose of the law. So the court cannot overlook the word subjects in this case.
Does the word subject have to have operative effect in every prosecution under the statute, or can it be simply one of the forms of prosecution?
Yes and no. It could. However, in this particular case, as applied, the word subjects was to be given to the jury. It was discussed in prior charge. Most importantly, it's on the jury verdict. It was before the jury for them to base their verdict on. Yet, inadvertently, it was left out from the jury instructions. So it wasn't defined, there was no judicial guidance, and it was left out by inadvertence.
But I mean, subjects is just one form.
Yeah.
Recruiting, enticing, harboring, and transporting are other forms.
True.
So what's wrong with that? I mean, you're suggesting that subjects really dominates the statute. It doesn't. It's just one form.
I'm not suggesting that subjects dominate. Yes, it is one form, but in this case, it's the most important one. Because in this case, we're suggesting there is no coercion or force, yet the element of coercion or force was part of the jury verdict. Yet, it was supposed to be part of the jury instructions, and it wasn't given as part of the jury instructions by inadvertence. Now, coupled with
coercion or force ever defined? That you're saying that was before the jury?
Coercion or force was never defined before the jury. Neither was the word subject.
Was that requested?
It was part of the pretrial motion as the statute being vague and asking for a dismissal. It was always an issue during the trial. However, it was shut down by the trial judge, so it was never argued further because it was essentially argued and dismissed by the trial judge.
You're saying that the jury decided the issue nonetheless?
It could have, Your Honor, because it was part of the jury instructions. It was the first word that appeared, part of jury verdict, and it was the first word that appeared on every single
And you're saying
verdict.
there was no evidence to support that?
There was no evidence to support that. There 3 prostitutes in this case were willing prostitutes.
Well, you don't know that.
They testified that
They were willing?
They
That all of
testified
this was
that.
willing? I mean, the Commonwealth's brief suggests quite the contrary set of facts.
Well, Your Honor, the Commonwealth's brief only suggests because they were supplied with drugs, now all of a sudden they can't consent anymore, thereby making a the protected class of prostitutes that are under the influence. I would suggest to the court, every one of these prostitutes, at least 2 of them, SC and BG, testified they were prostitutes before.
So what?
And in this particular case, they decided to leave when the
Prostitute not be raped?
No, Your Honor, I'm not saying the prostitute couldn't be raped, and in fact, in this case, they were found not guilty of rape. That is not. I'm not suggesting that.
That's by the defendants.
I'm sorry, I don't follow that.
Well, the rape was not by a client; it was by the defendants.
Yes, and they were found not guilty of every count. That is correct, Your Honor. And I'm not saying that prostitutes cannot be raped, but that's not what we're arguing here. What we're arguing here is that the lack of element of force or coercion now elevates statute from being pimping to now sex trafficking. And one last point I just want to make, Section 265.
Because the word subjects is there as one of the alternatives, it transforms the crime to one that requires coercion? That's your argument?
It could, because it's there as part of the statute.
I know it may
but
be
doesn't-
arguably one of the alternatives, but you make it sound as if it is a required element. Is that your position?
My position is looking at the legislative history, looking at Mass General Law, Section 265, Chapter 57, that makes an affirmative defense to prostitution only if you are sex trafficked and coerced and forced. What I'm saying is, based on legislative history, coercion and force was to be part of this legislation. It just was not put in clearly, and it's vague as it is.
So you're saying it is an element, it is a required element of the offense?
It needs to be, yes, Your Honor, in
I
order to
mean,
elevate
you
You're
say it
saying
needs
it
to
needs
be.
to be because you have a vagueness argument, but I think what Chief Justice Gans is asking, that was the legislative intent? I thought the legislative intent was exactly the opposite, not to include it.
Well, Yes and no, Your Honor, but looking at the legislative intent, yeah, I would suggest it was supposed to be part of it, coercion and force, because A, it's tailored towards the federal guidelines. B, looking at Section 57, giving an affirmative defense to prostitution only if they're coerced and forced. So why else would they have that? If there was the intent of the legislature that there was no coercion or force, then they would make it an affirmative defense to prostitution to be sex trafficked, period.
But that's a different crime. That's an affirmative defense to a different crime.
Prostitution,
It has
nightclub.
nothing to do with this statute, Section 50.
Well, Your Honor, I would say in order to interpret the legislative intent and in order to interpret a vague statute, one has to look at the statute that came before and the statute that were existent at the time, and through that prism, we can get to the legislative intent, the true legislative intent. Suggest to the court the statute that existed at the time, the statute we have, looking at other jurisdictions as suggested by the Commonwealth, although not binding. For instance, Kansas has no element of force, but it's specific, with or without force. Massachusetts statute, it's not specific. And the rule of lenity requires that if the statute is ambiguous, it has to be resolved in favor of the defendants. And in this particular case, Commonwealth versus Crosscup, this court had said, in light of heavy penalty, the statutory language needs to be clear. So what I'm saying, Your Honors, is that yes, force and coercion was the legislative intent. No, they didn't make it clear. And I would request that this court does so, as it does in home invasion statutes, upskirting statutes, essentially either interpret the law or have the legislative make their intent specific enough so that there is, this vagueness no longer exists.
Okay, thank you.
Thank you.
Morning. May it please the court, David Jelinek for Sidney McGhee. When it's stripped of the other verbiage and the Section 49 definition is replaced in, yes, there are multiple different forms of it, but whoever knowingly subjects, entices, transports, or harbors another person to engage in any sexual act on account of which anything of value is given, promised, or received by another person, is what the statute says. And that's overbroad on its face. There are broad First Amendment implications of that kind of language. It covers, as we talked about in the briefs, many other situations, and even one the Commonwealth concedes would be a taxi driver who might knowingly pick up a prostitute or someone who appears to be a prostitute from a hotel, drive them to another appointment, and knowingly receive some of those profits. They could be prosecuted.
If a statute, in an overbreadth attack, when a statute goes to conduct and not speech, as this one I would suggest does, don't you really need to look at what is the central core of the statute, and there's more leeway as to sort of marginal pieces that clearly your client doesn't come close to?
That's true, Your Honor, except that in this type of case where the potential scope of the non-intended consequences are much broader than the intended consequences, the intent in a lot of the case law is to look at the First Amendment implications. We're not dealing with a case of children being trafficked. We're dealing with a much broader statute. And in fact, there is a First Amendment speech implication here in the back page case, because one of the forms that the statute hits is enticing. Whoever knowingly entices another person. Backpage.com posts advertisements, and this was a disputed point in the Commonwealth's brief as well, but Backpage knowingly posts these ads. This is a case that touches on First Amendment speech issues because that statute would cover the publisher who might be putting that advertisement out knowing what they're doing, knowing that this advertisement covers those areas.
Sorry, so you're saying that it would not be a crime for somebody to advertise prostitution services?
Under this statute, it is a crime.
I understand, but you're saying that as a matter of the First Amendment, it cannot be?
Well, that's the Backpage.com case addressed that issue of what rules a state can impose on a publisher when they are advertising those services. This is coming up.
I understand there may be a line between advertising a dating service or advertising an escort service, but if it's advertising a prostitution
explicitly?
service,
Well, that's the line that's drawn in Section 49, which defines it as any sex act for which anything of value is given to another person. That's what the statute is trying to say, is that there are multiple legal things that might be advertised and multiple illegal things that might be advertised, but this statute covers them all, and that's why it's overbroad. That's why the overbreadth argument on the First Amendment touches on all those other things and makes the core of the statute too narrow to support it.
Okay, I mean, I'm now confused, because I understand that there may be a First Amendment issue to be overbroad in terms of the extent to which you are prohibiting the publication of information about escort services or dating services, because it may turn out that an escort service may be more than that. I understand that argument, but if the evidence were to be that there is an entity which is essentially advertising prostitution services and giving the prices for various sexual acts and then taking fees for that advertising, is it your view that the First Amendment would bar that prosecution?
No, I don't think it would. But this statute covers so much more than that. That's the argument.
Okay. Well, let me, how about, is it your view that this statute would would prohibit telephone sex? That the pay 50 cents an hour and have somebody talk dirty to you on the telephone?
The knowingly portion, which the Commonwealth argues creates enough scienter to narrow away from that, I believe it doesn't. I believe the statute does cover that type of advertising, because it's knowingly offering that advertisement, which you're acknowledging you're doing by rates and services, for the purpose of engaging in a sexual act on account of which anything of value is given or promised or received by another person.
And what is the definition of, I mean, the Commonwealth says sexual act requires there to be a physical sexual act.
Or we should interpret it as such.
Well, the Commonwealth is saying, of course we wouldn't prosecute people who don't do those things, like the mother who harbors her daughter, right? But they can. And in fact, the definitions of sexual act in other state statutes around the country are clearly defined. Here, this Section 49 covers much more than what's delineated in the case law and delineated in other statutes of touching or those types of acts, as opposed to performance or phone or nude dancing, for example.
How does this relate to nude dancing?
Well, again, any sexual act on account of which anything is given.
I didn't think nude dancing was a sexual act.
According to Section 49, it could be. That's the point. That's exactly it. That Section 49 defines this so broadly that it does hit those First Amendment and legal areas, and that's why it's an unconstitutional statute.
So let us imagine that we agree with you to the extent that we're going to prepare to write a decision which would narrow the scope and indicate that a sexual act must be a physical sexual act so as to bar that. Does that mean that your client gets off?
If the statute is simply narrowed in that way, probably not. In fact, though, he couldn't have known what would be deemed legal or illegal based on how overbroad the statute was.
Well, one can say that he's not exactly terribly close to the line here.
No.
That whatever it is, oral and vaginal intercourse in the context of the facts of this case are not at the edge of the scope of what we may be worried about here.
No, but this arbitrariness edge, where he may not fit right on the edge, but in the middle, the AG's report, which is part of the amicus briefs, indicates that there are multiple counties in which this is not being prosecuted at all. There are 0 prosecutions in Plymouth, for example, and many in another county, which implies, if I may, that it is a little arbitrarily enforced, but also that people don't know exactly what fits under the statute. And that's the very definition of it being too broad and unclear, too vague. He may not fit on the fringe, but he couldn't know either. A person of reasonable ordinary intelligence can't know if the prosecutors themselves can't figure out which cases do or do not fall.
But I mean, the problem, of course, I have in this case is pimping is not generally something which people don't know they can't do, and your client arguably were pretty classic pimps.
That may be true under 272.7. They didn't know that it would fall under this statute of trafficking.
But, so it's okay, it's unfair of the government to say, even though you know you're committing a crime, you didn't know you were committing this crime that has twice as much penalty? That's unfair?
If the elements of these particular acts are identical and that leads to the arbitrary enforcement, yes, Your Honor.
No.
Okay, thank you.
Good morning, Your Honors. May it please the Court, Matt Sears on behalf of the Commonwealth. I'd like to briefly acknowledge the amici in this case for their contribution and for responding to the Court's invitation to opine on this important issue. Amy Farrell, the Attorney General's Office, and the attorneys at WilmerHale, who wrote on behalf of Essentra Care Alliance, Coalitions Against Trafficking in Women, Children's Advocacy Center of Suffolk County, Demand Abolition, the EVA Center, and My Life, My Choice. The defendants in this case targeted women who were homeless, penniless, and alone. They enticed them with promises of money, apartments, and cars. They recruited and enticed them from in front of a hospital and a methadone clinic. They plied them with drugs and alcohol.
Would you say there was any use of coercion or force?
I would, Your Honor.
And where does that, so there was evidence of that, you say?
I would say so. Although it's not required by the statute, there is evidence of force, fraud, or coercion. 2 of the women testified that they were raped by the defendants, even if they're acquitted.
But the jury found them not guilty.
And I would argue that they found them not guilty of elements of a crime rather than conduct in terms of whether they can consider that for trafficking, force, fraud, or coercion. Additionally, they were, as I said earlier, plied with drugs, plied with alcohol. There were instances in the first 2 victims, CC and SE's cases, where they had serious reservations about what they were doing when the defendants gave them thong underwear, told them how to pose, took their photographs, and then posted them on the internet. In both situations, their concerns were assuaged by further enticement by the defendants of money, of cars, and of apartments.
But the jury was not asked to make any finding of fraud, coercion, or force.
That's correct, and that's why we don't even have to consider force, fraud, or
So
coercion.
it would matter only in terms of an aggravating element with regard to, not element, aggravating feature for sentencing. It doesn't have any bearing on the issue of guilt or innocence here.
And that's correct, and our position is that force, fraud, or coercion is not required. I was just answering Justice Link's question. The reason why force, fraud, or coercion is not required is because the legislature made a policy choice not to require it. I mean, we can argue all day about whether it was a good or bad policy choice, but it was a policy choice nonetheless. The TVPA, the federal trafficking statute, defines human trafficking without a force, fraud, or coercion element. They proscribe severe forms of sex trafficking, but they don't define sex trafficking with a force, fraud, or coercion element. And I think the express language of this statute shows the rejection. This statute says, by any means, rather than by force, fraud, or coercion.
So, but that leads you then, let's accept your point that that is exactly what the legislature intended. So then you get to the question of both overbreadth and vagueness, right?
Right, Your Honor.
And you say, I think principally, that the word knowingly helps a lot in narrowing the possibilities here. But as I think the defendants have pointed out, there are certainly examples where somebody could be transporting or doing other things, not what their clients did, but doing other things that certainly fit knowingly and certainly fit right within the statute that may not be where it really was intending to go.
Sure.
So.
And I want to answer your question, but I want to also provide a framework from which we can answer that question. This court recently, and I included in a 16L letter on March 11th, Justice Spina authored a decision that touched on facial vagueness, that touched on vagueness as applied, and that touched on the application of third-party standing in First Amendment challenges. When we say knowingly, knowingly incorporates, it's at the very, very beginning of the statute, knowingly incorporates all of those facts, all of those verbs. It also incorporates to engage in commercial sexual activity. That to engage in is read with knowingly. So the taxi driver, which again, the taxi driver, if he knowingly transports a prostitute to engage in prostitution, he certainly can be charged under the statute. But I think a very important thing to think about in Chief of Police versus Holden, which is your recent opinion, when the defendants conduct, as it does in this case, falls so squarely within the proscribed conduct of the statute, he doesn't have standing to challenge its unconstitutional application to other parties. So they can't, the defendants, again, every single step of the way falls within this statute. And because their conduct falls within, as this court has said, as the Supreme Court has said, the hardcore of the prohibited conduct, they cannot be heard to challenge the constitutionality as applied to another person.
Do you, as part of what you've just said, is part of that accepting the view, Chief Justice Gantz's point, that we need to interpret the definition of commercial sexual activity as requiring some physical contact, sexual activity that involves physical contact?
I don't think you need to. I think the case law makes it clear that a sexual act, all that this statute says is a sexual act.
Well, is speaking over the phone, whatever those calls are.
Is that a commercial sexual activity?
Yeah, is that commercial sexual activity?
Well, as the statute's defined, commercial sexual activity is a sexual act. So we have to first determine whether that's a sexual act. The case law in Massachusetts has not defined anything like that as a sexual act, and I haven't found any federal law that has defined that as a sexual act.
So you're suggesting that we need not interpret act to mean act and exclude speech?
To exclude speech? I don't think that any speech is implicated. I mean, the exception to the third-party standing rule is that if the defendant, and it's the defendant's burden to show this, that this statute somehow is overly broad so that it does impinge some First Amendment right, some First Amendment protection in a real way, and the defendant has failed to show that in a real way there is any protected aspect of a sexual act.
Well, let me ask you this. Would you call nude dancing a sexual act?
I wouldn't, but I don't think we need to get there because this jury was only instructed on commercial sexual
No, I'm just trying to get to what the parameters of this are. I mean, I thought you were suggesting, but maybe I'm wrong, I thought you were suggesting that an appropriate interpretation of the definition of commercial sexual activity would be one that focuses on some kind of physical contact.
I think that is the appropriate interpretation. It certainly is what happened in this case. You had oral and vaginal intercourse in exchange for money. And just to refer back to the statute, so commercial sexual activity is one of three ways that the defendants could have violated it. The statute. A sexually explicit performance or the production of unlawful pornography in violation of Chapter 272. So, I mean, in terms of nude dancing, maybe that's arguably under a sexually explicit performance.
We actually have said it's covered by the First Amendment.
And in that case, if that were the case, if we did have sexually explicit performance and not clearly prostitution, then that would be a peripheral, a marginal, a de minimis infringement on the First Amendment when compared against the clearly legitimate sweep of this statute.
Well, what if it was the owner of the dance club, the nude dancing club, and he was being, or she was being prosecuted for permitting nude dancing, and said, you're impinging on my First Amendment right to present nude dancing? It wouldn't be peripheral in those circumstances, would it?
I think peripheral in relation to what this statute does prescribe, which is sex acts in exchange for money, prostitution, that type of behavior. So whether or not that owner, whether or not the violation that owner makes is considered peripheral to the violations that this statute plainly prescribes, certainly. And again, this court and other courts have said, the Supreme Court has said, those issues, those scenarios can be addressed and cured on a case-by-case basis. And I think that's Broderick versus Oklahoma, Commonwealth versus Balmer, Commonwealth versus Disler, and the recent Holden decision
Because the Holden decision was a Second Amendment case.
It was, and this court said the Second Amendment is not a First Amendment, so we're not even going to get to the third-party standing rule. The only reason that we're entertaining that today is, again, because
Well, there is a vagueness challenge here, too.
there is, but I think the vagueness challenge is easily met. The defendants, as applied, the defendant's conduct falls expressly, clearly within the conduct prescribed, and per Commonwealth versus Gallant, they have no as-applied challenge. The facial challenge is equally meritless. Facial challenge has to show that in no circumstances could this statute be validly applied. And I think this fact scenario, this specific fact pattern shows there is no vagueness on either ground.
What do you say to this argument that, hey, all we were doing was pimping, we weren't doing nothing else?
So I think pimping is not an element of sex trafficking. It's not, I would eschew the use of pimping. Massachusetts takes a strictly elements-based approach when we determine whether or not one statute...
Never heard anybody use eschew verbally before. Congratulations.
Whether, there's the first time for everything. Whether or not these two statutes are the same thing, whether or not they contain the same elements. Just because there is overlapping proof does not mean that the statutes are duplicative or that someone would not be on notice. It would be like saying an armed robber cannot be convicted of felony murder because he thought he was just an armed robber. So what we have is a clear element that is distinct and different in each criminal statute. In the deriving proceeds, Chapter 272, Section 7, there must be a sharing of the proceeds connected to the prostitution. That's not required in Section 50. In Section 50, there must be the recruitment, enticement, harboring, transporting, all of those verbs. That's necessary to violate the statute. That's not required under 272, Section 7. So what I would encourage the court to do is consider a prospective defendant or a violator of 272 Section 7 versus a prospective violator of 265 Section 50 and what they would think. And I think that solves the vagueness challenge and dismisses of the defendant's arguments in that regard.
The sentence, I know this is the tail wagging the dog, but the sentence on the prostitution, the 5 to 5 in a day.
Right.
I mean, yeah.
I looked that up last night to confirm that that's what the sentence was. I believe Section 7's maximum sentence is 5 years.
That would have to be redone. Right?
Correct. I don't think it could stand at 5 years.
4 years, 364 to 5, but not 5 to 5 in a day.
Sure. I mean, he got a sentencing range of 5 to 5 and 1 day. I think, don't know that a remand is necessary to get to the 5 if the court.
Well, you need a
feels it is.
bottom number.
Right.
So
potentially it could.
Could the under this statute, could the person who is engaging in the commercial sexual activity also be charged as violating the statute for knowingly transporting himself or herself to a location for commercial sexual activity?
So because we don't have that, the short answer is no. The long answer is because the defendant's conduct falls so squarely within the statute, the defendants cannot even challenge that application as unconstitutional. A defendant or a person in your hypothetical who transports themselves for purpose of commercial sexual activity is not protected by any First Amendment right. The Supreme Court and this court have found that prostitution is not protected. So I don't think the court even needs to get to that hypothetical.
All right, thank you.
Counsel.
Thank you, Honors.
We will eschew further argument.